Well, good evening, everybody, and thank you for joining us. My name is Desmond Hudson. I'm Chair of Regulation Board, and I have the pleasure of chairing tonight's event. So let me, first of all, draw your attention to the fact that I'm accompanied here on the table by members of the Working Party and members of the IFOA staff. You'll see the details of the Working Party, I think, in the consultation materials that you collected at the beginning. What we're about on this first consultation event is seeking out your thoughts, your views, and your feedback into the consultation process. The consultation process closes on the 17th of January, so there's lots of time, no excuse for not letting us have your consultation views and thoughts and suggestions in due course. So, with that in mind, perhaps I can start by asking my colleague Elena McLachlan, one of the IFOA executive who has worked on this project to support the Working Party, who's going to take us through a few slides to set a context. Now, this context is all about providing you with some background and the approach that we've taken, and I hope it will inform your access to the discussions that are going to follow. Elena, over to you.
Thanks, Des. I'd just like to echo Des's comments. First of all, to say welcome to everyone, and thank you so much for coming along. It's wonderful to see so many of you interested in the code consultation. So in terms of the presentation this evening then, I'm going to, the programme's there on the screen. Firstly, I'm going to talk through a little bit of the background to the code review and the consultation. I'll then give a brief overview of the proposals. Hopefully some of you, if not all, will have already seen the full consultation document, but I'll go through the proposed changes for the benefit of those who haven't. And I'm then going to talk a little bit about next steps and how your feedback can feed into the consultation process. And then finally, we'll open up the floor to some questions for the panel. So I can't start talking about the review of the Actuaries Code without talking about our wonderful and enthusiastic Working Party members. So as Des has said already, he's the chairman of the Actuaries Code Working Party. We've also got with us today Wendy Walford and Neil Warmby, who are members of the Working Party. Not with us today, but also members are Alan Watson, Alison Carr, Malcolm Slee, and Alan Watson. So I guess the first thing to do is really to pass on the IFOA's sincere thanks to the Working Party for their very, very hard work over the last however many number of months. They really have put in an enormous amount of effort to get us to the stage where we're able to present these proposals to you this evening. So thank you very much for that. So, background to the review then. Well, it's worth saying that this is the first substantive review of the Actuaries Code since it first came into existence in 2009. We carried out a light touch review of the code in 2013, and that resulted in some tidying up of the code and a few changes, but really the code hasn't changed all that much since it first came into force in 2009. The IFOA has, however, changed quite significantly since the code first came into force. We now have much more members working internationally. Our membership has grown, and we've got a lot more members working in wider fields. So against that background, the IFOA's Regulation Board decided that the time was ripe for a substantive review of the code, and that's really what's led us to this stage. So, as I've said already, a working party was established to carry out the review, and its terms of reference were to look at, firstly, whether the code remains fit for purpose in light of experience since 2009, whether the code appropriately reflects the role of individual actuaries in terms of protecting the public interest, whether the code is in line with Regulation Board's agreed regulatory principles, whether the code is fit for purpose in the current regulatory environment applying to IFOA members, whether the code appropriately reflects the international nature of the IFOA's membership, and also any issues arising from the IFOA's Risk Outlook project or the Joint Forum on Actuarial Regulation, JFAR for short, its risk perspective, any issues that are deemed to be relevant to the code, and finally, how the code interacts and fits with the FRC's revised framework of technical actuarial standards, which obviously came into force in July of this year. So how did the Working Party go about conducting the review? Well, it's worth saying that long before pen was put to paper, there was an enormous amount of effort carried out by the Working Party in terms of analysing and carrying out research into the code. They did that by information gathering about known or identified issues with the code, with the existing code. They also carried out benchmarking exercises looking at the code and how it compared to the ethical codes of other regulators and actuarial organisations. They also carried out an informal consultation exercise with a number of different key stakeholders to obtain feedback on the potential impact and the effectiveness of the revised code and the proposals that are before you today. And that informal consultation included the practice boards and the practice standards committees of the IFOA, also the IFOA's regulatory partners, so for example, the FRC, the FCA, the pensions regulator and the PRA. And they also spoke with those who are involved in interpreting the code in a disciplinary setting to see how the proposals would land. So I'll go into the proposed changes in a bit more detail further on in the presentation, but in general terms, what you can expect to see in the revised code is first of all a clearer structure, and that aims to set out more clearly the status of the subparagraphs, or as we're calling them now, amplifications of the code against the headline principles themselves. So some of the feedback that we received is that sometimes the status of those subparagraphs isn't necessarily clear. So the new code has been revised and aims to address that. The code uses a more simple language, and a lot of the principles have been streamlined to make them clearer and more accessible and more concise. And there's been a real effort made to ensure that the code is relevant to all members, no matter where in the world they're working or whether they're working for a consultancy or in an in-house setting. So, for example, you'll see that references to UK legislation have been stripped out of the code, and also references to firms have been changed to users in an attempt to make it more all-encompassing. So, some of the feedback that we had in relation to the existing code was that the language used in the existing code doesn't always make it clear what the obligation is in relation to each of the principles. So what you'll see in the new code is the use of the words must and should to help clarify this. The revised code also introduces a new standalone speaking up principle to emphasise the importance of those particular provisions and to introduce clarity around members' obligations in relation to speaking up. And I'll talk a little bit more about that as we go on. You'll also see that where more prescriptive or process-based wording has been removed, it's been incorporated into the guidance document that's proposed is going to accompany the new revised code. And the aim of that guide is really to provide some practical guidance to help members understand their professional and regulatory responsibilities under the code. So turning now to the structure and layout of the revised code then. You'll see that it continues to be a high-level principle-based code. So it does place quite a lot of emphasis on encouraging the exercise of professional judgment, as does the existing code, rather than adopting a more rules-based approach. The new code, you'll see, has increased from 5 to 6 principles. You'll recognise most of the principles, 5 of them haven't changed. The addition of the speaking up principle is retaining a lot of the requirements that are there already, but just elevating them into its own principle in its own right, just to highlight their importance. And as I said, the code is supported by what are now called amplifications, and those are non-exhaustive examples of the types of behaviours expected of members. When considering the structure of the code, the Working Party did look at other options for alternative structures. And they looked at, for example, separating the principles into standards of service and standards of conduct, but they decided in the end that the existing structure really works quite well, and that to change the structure would result in quite substantial revisions to the code, which wouldn't necessarily be beneficial, and it wasn't something they were keen to do. So the structure of the code has been left broadly unchanged. So the application section of the code remains largely unchanged. Some additional wording has been added to saying, so it now reads as, the code applies to all members of the Institute and Faculty of Actuaries in all locations. And that additional wording has been added really in response to feedback that it wasn't necessarily clear, or it isn't necessarily clear in the existing code, that the code applies regardless of where a member is based. And that's obviously the case, so this wording has been added to try and clarify that. There hasn't been any change to the scope of the code, but some of the wording in that section of the code has been revised. So the scope of the code has been changed from members' conduct in their work as actuaries to members' conduct in relation to an actuarial role. And this change reflects the feedback that the wording of the existing code, on the face of it, doesn't reflect that the code also applies to other members of the IFOA who aren't qualified actuaries. So, for example, student members and certified actuarial analysts. This was another change that the Working Party debated at some length, and they did look at a number of different alternatives to actuarial role. Again, they decided that there were pros and cons to the different options, but in the end decided that the actuarial role wording is the clearest for capturing the distinction between a member's conduct in an actuarial role and their other conduct. But of course, I'm very interested to hear what other people have to say about that. The wording in relation to members' other conduct outside of a professional role has also been amended to make it clearer that if an action might have implications for the profession as a whole, it shouldn't matter that that activity is outside of a member's role as an actuary, and that it will still be caught by the code. So again, that's something that it doesn't change the position from the existing code, but the wording has been amended just to make that a little bit clearer. The status and purpose is another section of the code that's been amended to introduce a little bit more clarity. So the first change is in relation to the wording relating to members' obligation when it comes to protecting the public interest. The wording of the existing code is that the code consists of principles which members are expected to observe in the public interest and in order to build and promote confidence in the work of actuaries and in the actuarial profession. The revised code amends this slightly to reflect the IFOA's refreshed regulatory policy statement, which sets out what's expected of members when it comes to protecting the public interest. And it's quite a subtle change, but the new wording that appears in the revised code is that the code includes six principles shown in italics which members must observe to support the profession in acting in the public interest. Again, additional wording has been added in the status and purpose section of the code to clarify the structure of the code and explain the status of the headline principles against the sub-paragraph. So there's a lot more in that first section of the code in terms of explanation of what the code is and what it sets out. So, as I said before, it sets out that the sub-paragraphs, which are now described as amplifications, are specific requirements of the principles for some particular issues. And that's the same as the position under the existing code, but that wording's been added to make that clear. And there's also been wording added to make it clear that members are expected to comply with both the headline principle and the amplifications. And that's in response to feedback that isn't necessarily clear in the existing code. I think I've already mentioned the uses of the word must and should, and that's again set out in this status and purpose section of the code. And lastly, in this section, there's been some new wording added, which is to remind members that nothing in the code is intended to require them to act in breach of their legal requirements. So therefore, if a member is acting in a way that is on the face of it contrary to one of the requirements of the code, and their actions are to comply with the legal requirement, they won't be treated as having breached the code. Again, this isn't a change to the position in the existing code. The same approach already applies, but it's been explicitly set out in the revised code to provide members with clarity and in recognition of the fact that from time to time members might be required to comply with legal requirements that will take precedence over the code. And the example that's cited in the consultation document of this is the UK money laundering legislation, which prohibits individuals from tipping off those who are being investigated for criminal conduct. So it's those kind of exceptions that are caught under that new wording. So I'll talk a bit now about the principles themselves and the changes that are being proposed. So as I've said already, the revised code increases from 5 to 6 principles, but largely they remain the same. 5 are the existing principles, and then there's this new speaking up principle which captures some of the requirements that are already in the existing code. The first of the principles, as with the existing code, is the integrity principle. And if you've looked at the revised code, you'll see that this has been somewhat shortened and simplified, and the headline principle has changed from a must, has been changed to a must rather than a will. The requirement to show respect for others is still there, but it's no longer qualified by reference to members' professional lives. And that change has been made to reflect the general scope of the code, which talks about the code applying to members' other conduct, if that conduct could reasonably be considered to reflect upon the profession. So that change reflects the view that, in light of what the scope of the code says, it doesn't really make sense to qualify that to a member's professional life, and really it should apply at all times. A further change is that the specific qualification to the confidentiality principle permitting disclosures where required by law or permitted by law and justified in the public interest has been removed from the code. So that's not to say that that qualification no longer applies, but the Working Party felt when considering the existing code that the qualification wasn't really necessary anymore in light of, first of all, the wording about compliance with legal requirements that's been added to the status and purpose section of the code, which I spoke about just a moment ago, and also the requirements, the general requirements of the compliance principle. So information about those qualifications are now included in the, the supporting guide. The requirement to respect confidentiality has been drafted as a should requirement to reflect the fact that there are potential exceptions to that requirement, for example, speaking up about breaches that are permitted by law. So again, it's a should rather than a must. And finally, the requirement for members to be honest, open and truthful in promoting their business services has been removed from the revised code's integrity principle on the basis that it's considered to be inherent in the overall principle of integrity, and so not necessary to state it separately in the principle. So turning now to the revised competence and care principle. So again, it's been revised to make it more principles-based and to try and remove some of the more prescriptive and process-based requirements under the existing principle. And those more process-based requirements have been moved to the accompanying guide. And that includes, for example, the requirement to act under direct supervision of another where that's appropriate. So again, the removal of those provisions doesn't mean that they aren't considered to be important, but simply that they don't really fit under a principles-based code, and in any case are inherently part of the requirement to act with competence and care, so don't really need to be separately stated under the code. Some changes have been made to the existing amplification, which requires members to keep their competence up to date. And you'll see that in the revised code, this has now been, it's been reworded and expanded so that there's now 3 clear aspects to this requirement. The first is for members to ensure that they have an appropriate level of relevant knowledge and skill to carry out a piece of work. So that's the requirement to maintain sufficient knowledge and skill to be able to carry out a piece of work competently. The second aspect to it is to continue to develop knowledge and skills. So that's a general requirement for ongoing professional development. And then the third aspect to that requirement is to comply with the IFOA's continuing professional development scheme, so the CPD scheme of the IFOA. And that introduces a specific requirement to comply with the IFOA's expectations in relation to members' competency as set out in the CPD scheme. So the changes here haven't really introduced all that much that's new, but the changes that have been made have been drafted to highlight the fact that professional competence isn't something that's static, but it's continuously evolving. So as well as having sufficient knowledge and skill to be able to competently carry out a piece of work, members also need to be engaging in further professional development. And the specific reference to the CPD scheme is in response to feedback from members that should really be referenced in the code. So the next principle is the impartiality principle. And again, the first change to the principle is pretty self-explanatory. The headline principle has been reworded, and it clarifies now that in addition to ensuring that their professional judgment is not compromised, members must also ensure that they cannot reasonably be seen to be compromised by bias, conflict of interest, or the undue influence of others. The requirement for members to ensure that they're aware of any relevant interest, including income of their firm, has been changed to any relevant interests that might create a conflict. And when considering this particular section of the existing code, the working party agreed that it was appropriate to have a wider requirement to be aware of any relevant interests that might create a conflict, not just financial interests, and that the requirement for members to be aware of the income of a firm might not be achievable in all cases. So for example, for more junior members or for those working in an in-house setting, some of these types of members might not necessarily always be cited on these types of things. So a wider obligation was more appropriate. And the remaining changes that you'll see in the competence and care section, the impartiality section of the revised code aim to bring it in principle with the more principles-based style of the rest of the code. So again, any provisions that can be described more as guidance or process have been moved into the accompanying guide. So compliance then, the main change to the compliance principle is this addition of a new amplification requiring disclosure to the IFOA of any conviction, adverse finding, judgment or disqualification described in the IFOA's disciplinary scheme. It's worth noting at the outset that this isn't actually a new requirement. It's new to the code, but it's something that is already set out in the IFOA's disciplinary scheme. And the reason that it's been included in the revised code is to reflect feedback from some that it's really important that this is captured somewhere that isn't just in the disciplinary scheme of the IFOA, to avoid the risk that members only look at that scheme when they're subject to disciplinary proceedings. So it's been brought into the revised code really to give it prominence, to make sure that members are aware of that. Those who've already had a look over the changes will notice that the compliance principle has been stripped down somewhat. And that's because a lot of the speaking up provisions which are in the existing compliance principle have now been moved out into their own separate standalone principle, as I've already said. And that includes the requirement to challenge non-compliance by others. So I'll go on to talk about that new principle next. So as I've said already, the speaking up requirements aren't all necessarily new requirements. They were previously under the compliance principle, but they've been elevated and moved up into their own principle just to highlight their importance and to make sure that there's clarity around members' obligations in relation to speaking up. I think some of the feedback that we've had is that to some members, the requirement to speak up is just a whistleblowing requirement. And hopefully the new revised principle shows that actually the obligation is a bit wider than that. The new principle, the obligations under the new principle have been shortened and simplified. And hopefully the language is a little bit clearer than in the existing provisions in the existing code. And as I said at the outset in the introduction, references to UK legislation have been removed from this section so that the provisions are relevant and apply no matter where a member is based. The requirement to speak up to clients or employers or both is described in the revised code as a general requirement to speak up. And this change is really to reflect the fact that it might not always be appropriate for members to report something to their employer. There might be someone who's more appropriate or more relevant to report to. So this introduces an element of judgment to allow members to determine who the most appropriate person to report to might be. The requirement to speak up about improper conduct has been removed, and the main requirement to speak up is now restricted to unethical or unlawful conduct. And the reason for this change is really to reflect feedback from members that they aren't always necessarily sure what is meant by improper conduct. And the idea is also that any conduct that can be described as improper would, in most cases, also normally be described as either unethical or unlawful, or both. And in terms of issues of competence, which some people have commented on, those will, in most cases, be caught under the competence and care principle. And that, in turn, under the revised code, would trigger the speaking up principle. And in particular, amplification 5.2, which is that members must report to the IFOA without delay any matter which appears to constitute misconduct and/or a material breach of any relevant legal, regulatory, or professional requirements by one of its members. So that's really the rationale for removing that improper conduct wording in the speaking up principle. The next change is one that was also debated at length by the Working Party, and that was to introduce a materiality test in relation to the requirements to report matters to relevant regulators and other authorities. And the reason for the addition of that materiality point is really to ensure a proportionate approach to reporting and to allow members to use their judgment to determine whether they consider that a breach is likely to materially affect outcomes, to avoid having to report every single minor error that they might come across in their day-to-day work. So that amplification has also been drafted as a should requirement to take into account situations where it might not be appropriate or it might not be necessary to report. So for example, where a report would be prohibited due to a legal requirement, or where a report has already been made by another person, and to do so again would be a duplicate effort. And then finally, under the new speaking up principle, a new amplification has been introduced which requires members to take reasonable steps to ensure users are aware of any substantial issues with a piece of work. And really the purpose of that is to protect the interests of users and to ensure that they are notified whenever there is any significant issues that occur with a piece of work. So moving on to the final principle then, communication. Again, this is one of the principles where the wording has been shortened and simplified in line with the approach taken in relation to the rest of the code. The revised communication principle includes the requirement for members to communicate appropriately rather than effectively, which is the wording in the existing code. And the Working Party, when they were considering whether to make this change, took into account feedback that while sometimes where an outcome is out of a member's control, they might not always be able to ensure that communication is effective in producing a desired or intended result. However, it is possible for them to ensure that they are communicating in a way that is suitable or is proper in the circumstances. So this really seemed like a sensible change and one that's intended to help members with their obligations in relation to this principle. Again, in relation to the communication principle, the more detailed provisions which deal with more process-based requirements rather than principle-based requirements have been moved into the guidance document. The requirement for members to ensure that communications are accurate and not misleading has been qualified, and the revised amplification instead requires members to take reasonable steps to ensure that a communication for which they are responsible or in which they have a significant involvement is accurate, not misleading, and contains an appropriate level of information. And that's really just in recognition of the fact that where a member is not responsible for the entirety of a communication, it's not always possible for them to ensure that it's accurate and not misleading, and they can only really take reasonable steps to do so. And then finally, a new requirement has been introduced requiring members to notify users of any adverse impact where they feel the user has misunderstood or misinterpreted their advice. So I'll mention briefly a bit about the accompanying guidance document that's proposed in the consultation. It's intended to be a non-mandatory piece of guidance to sit along with the other pieces of guidance which are produced by the IFOA. And really the purpose of it is to try and help members understand their obligations under the revised code. The guide includes separate chapters dealing with each of the principles, as well as sections on the application's scope and status and purpose of the code. It's worth saying here that for those who've had a look at the guidance document, you'll see that it incorporates some of the existing pieces of guidance that have already been published by the IFOA. So it includes the guidance for members on conflicts of interest, and also the whistleblowing guidance that is currently published. So the idea here is really that there should be this reference point for members where they can, if they're looking for guidance on the revised code, they should be able to dip in and out of that and use it as a bit of a reference tool. So the guide is a bit, it's relatively comprehensive, but it's not intended to be looked at from cover to cover and to be read in one go. Rather, it's more to be looked at as a reference tool to be dipped in and out of. So, next steps then. So, as Des said, the consultation is open for responses until the 17th of January 2018. Once the consultation is closed, the responses will be summarised in a feedback paper, and we're expecting that to hopefully be published in early spring, but it will obviously depend on the volume of responses that we get to the consultation. The feedback will be considered by the working party and fed back to the IFOA's regulation board, after which the board will consider the feedback and determine to what extent they want to approve the proposals or whether any changes need to be made to the revised code and the accompanying guide. Once agreed, we're expecting that there's going to be a relatively long period for transition needed before the proposals come into force. And that's really to allow us the opportunity to make any changes that we need to make to the existing literature that's published by the IFOA. The code's obviously an integral part of all of the standards that we developed at the IFOA, so there'll be quite a lot of documents that need changed before the revised code comes into force. So in terms of how to respond to the consultation, then that's obviously all set out in the consultation paper. Hopefully some of you will have had an opportunity to respond to that already. If you haven't, please do take a look at the proposals and give us your thoughts. You can do so by either emailing code@actuaries.org.uk, or probably the easier way to do it is by completing the online questionnaire that you'll find on the IFOA's website. And the easiest way to do that is probably just to access the code page of the website. So that was the quick canter through the proposed changes to the code, and I'll now pass you over to the panel for the Q&A section. So thank you very much.
And thank you for that, and thank you, colleagues, for your attention. Now, this is your opportunity to make your points and to share your views. Can I remind you, we are recording this, so wait for the microphone to arrive, speak into the microphone, and if you could announce yourself before making the question. So, who'd like to go first? Sir, down here on my right.
David Everett. I have a question really about the guide. I was somewhat taken aback by the length of the guide, and it's very different to guides which have accompanied other professional conduct standards. The beauty of the Actuaries Code as it currently stands is it doesn't need a guide at all. It's all self-contained. I can understand why, if you are to shorten the wording in the Actuaries Code, you need some form of guide. But to me, having a 48, 50-page guide, and I can see why you've done it, risks people not reading the guide at all and just relying upon a shortened Actuaries Code, too shortened, in my view, if they're not reading the guide. So my suggestion is that there needs to be a guide if you continue with the shortened version of the code, but that guide should be much, much shorter than it currently is, and its objective should be to explain some of the phrases and the sentences used in the shortened Actuaries Code. And where it's necessary to go into more detail, such as that on conflicts, then that should stay as a separate document. Because we do want people surely to read through the whole guide to get a flavour for what this new Actuaries Code is about.
Thank you for that. I think if you pass the microphone behind you, I think we have a related point on this question of the guide.
You read my mind perfectly. Yes, Simon Khan. I would like to back up and support that point on the guide, but with some different arguments. Mm-hmm. There's a bit of a history here. In the past, we had an equivalent code and guide that sat side by side, and over time, it became apparent that changes to the guide were actually introducing new rules or provisions, and it ceased to be a guide. And people said, can't they be merged? So they were merged into a single document, and people were happy until they realized that this was actually quite a long document, and they then said after a while, could it not be made shorter? Uh-huh. So we got a much more succinct code, and then after a while people said, couldn't there be a guide? Now, you might think I'm expecting that the next step will be that changes will be written into the guide that will make rules. In fact, the drafters have beaten me to it. They've done it already. The guide is riddled with the expression members should or you should. And as we know from the code, when we're told that we should do something, that isn't compulsory, but it creates a presumption that we will act in that way. So whereas the code has 5 shoulds, 5 presumptions that we will act in a particular way, the guide actually has 50, something like 50 of them. So far from being non-mandatory, it's at the very least mandatory that you'll read it to understand the degree of presumption that's being placed on you. What then is the solution? I'm not suggesting the guide be torn up and thrown away, because there's a lot of good stuff in it. My suggestion for a solution would be to rewrite it slightly, to take away the shoulds, have it as an authored document, not a publication of the IFOA, but a publication of the people who actually wrote it, and that it should express their opinions as individuals or as a working group, so that it's quite clear that this is not official dicta of the IFOA, but it's opinions of a group of people expressed as we suggest that, or we believe a disciplinary tribunal is likely to accept the following, things like that. So it's truly a guide. And just before I hand the microphone over to whoever's next, could I just say that with regard to the code, it's much more succinct, it's much clearer, it's much more direct, and if it's true that it was written by actuaries, they're obviously in the wrong profession, but I do congratulate and commend them on the code, and I feel obliged to put that in, having been sceptical about the guide.
Thank you for that. Are there related points on the question of the guide? So we could deal with that first. Is your point about guide? We'll come to you at the front here, and then we'll go, I think, to my left. Sir.
Thank you. John Spain. I would go further than either of the two previous gentlemen. I would junk the guide, because if actuaries can't be grown up to understand what is pretty clear, then perhaps they're not grown enough to be fully qualified FIAs, FFAs, whatever we're going to call the next generation. Am I allowed to add 2 other things, please?
I'll come back to you for the 2 other things. I want to try and keep it tight to the question of the guide, and we've got somebody to your left who wants to come in, but I will come back to you, honest.
Hello, I'm David Martin. I'm just speaking for myself. I've been looking at this through the eyes of the IAA and the AAE, the international organizations, which I'm very much involved in. And I'm very much in favor of principles-based regulation of all kinds, but I just wonder if it's gone a little bit too far this time. I know that those organizations look at the code of conduct, which is a requirement of membership, to see whether whether it passes muster or not, and I've actually can show the scars of having to cope with explaining the previous code. But this one is much more cut down. You would think that principles-based or the opposite are binary, but they're not. There's a spectrum. And I just wonder if we've maybe moved too far. So my question is the guide, what is the legal status of the guide? If someone were before a disciplinary hearing and the guide was being quoted, would that individual be able to suggest, maybe with legal advice, that, well, his interpretation of the guide is, of the code rather, is different and is not the same as in the guide, because the code doesn't actually refer to the guide at all. So that was really my question. Thank you.
Okay, right, well, I'm going to pause there, colleagues, and let's listen to colleagues from the Working Party dealing with those questions. Who'd like to go first? Wendy or?
Well, I think the use of the guidance was something that we did talk about to quite a large extent, and how much should go into the code versus the guidance. We definitely felt that we wanted to keep the code to be very much principles-based, succinct and clear. And I think those were our guiding principles there. We did want to go along and move the procedural sides into the guidance, and I think you can see that coming through. And we reflected to try and make sure that when you do go principle-based, it can become a bit harder to understand what the intention is, and so that was really where we thought the guidance was a good supporting document to be given. Going on from that, I think there was a question about the length of the guidance, and that was something that we did debate about, and I think the main contributors to the length is the fact that we've incorporated a lot of guidance that is currently issued by the profession, particularly around whistleblowing and conflicts of interest. They are 2 very complex areas that we didn't want to shorten that guidance or have multiple versions out there. So we wanted to have it all together. One of the things that we did also discuss is how it would be accessed. And I think there the use of perhaps potentially moving the guidance to being more internet-based, where you can click into various parts that you're looking for, addresses a bit more a question on the length, because you could then have the conflicts of interest and the whistleblowing as separate links that you go to that would help with that readability. So I think those were some of the main considerations that I took away from where we
Neil, do you want to add anything?
Well, just to echo those points, but I appreciate, as a practicing actuary, yes, 48 pages is a long document to read. Echo the points about conflicts and whistleblowing, which I think are existing guidance. And I think the rest then, if you look at it, a lot of that actually is some of the procedural stuff that was in the code that we pulled out. We felt it was still useful to have somewhere. And there's also a few UK-specific references that we thought for a lot of the UK members would still be useful. So I think that's why we ended up with a guide as long as it has been. Just to echo the thoughts about how we publish it, I know it's published here as a 48-page document, and in a sense that was reflecting an idea of having one sort of reference would be very useful. But I think when we actually put it onto the web, possibly we might explore ways of having shorter extracts of it. So whistleblowing will still be whistleblowing, conflicts will still be whistleblowing. So we're very mindful of those comments, and I think I have a lot of sympathy with those comments about length. We will take those away and weigh those up about how we then look at that.
And I suspect I should probably respond to the points made by Simon and David. Simon, you made the point that you thought it was, in effect, riddled with rules because we're using the word should. Now, clearly, we're going to have to go away and think about that. But it's worth stressing that at the very outset of the guide, we make the point, and it's paragraph 110, and this, I think, also goes to your question, David, about the legal impact, if I can use a paraphrase of the guide. Paragraph 110 says the guide is non-mandatory guidance. It imposes no obligation upon members over and above those embodied in the code or APSs. So we're trying to use should because we think there is some clarity and some benefit from consistency with the way we use must and should, for example, in an APS. And we need to reflect on that in the light of your challenge, Simon. But we're trying to say that this is non-mandatory guidance. It would not necessarily, therefore, is not binding. It creates no new obligation. But if a member came along and said, well, look, I have followed this guidance, how can you now be bringing me before a disciplinary tribunal? That clearly would carry considerable weight. It would be an issue that would need to be thought of. It would be considered before we got anywhere near a disciplinary tribunal. So the idea behind this is that it's not intended to add any new rules. It is not intended to extend or expand any obligation that we propose in the code. If we've gone too far, then we need to reflect on that. We've also got that question that David was question challenges on in that sense. Well, have we made the principles too minimalistic, too brief, too short, which has perhaps driven the expansion of the guide? So clearly we'll reflect on all of those points. Now, is there anything else anybody wants to raise about the guide? Yes, so just wait for the microphone, it's just coming to you. It's in the middle on my left towards the front. You got it?
Thank you. It's John Instance. I mean, I have sympathy with everything that's been said. I mean, the guide is too long. One of the points I thought is, of the something like 48 pages, 60% deals with speaking up, 15 or 20% deals with conflicts of interest, but actually hardly anything to do with any of the other principles. And I just worry whether this is actually... Now, I appreciate conflicts of interest are very complex. And speaking up, it can be difficult. But nonetheless, it sort of indicates, those are the sorts of things we really worry about. I was just thinking, it needs to be separate. I mean, why have we only got 3 paragraphs on integrity? It's just that sort of thing.
Okay, thank you for that. Now, so you very kindly passed on the microphone when you had 2 more other questions, I think, to raise. So let's bring the microphone back to the front here. Floor is yours.
Thank you. The first thing is on competence and care. In what is proposed as 2.3, members must ensure their work is appropriate to the needs and, where applicable, instructions of users. Members are not qualified to decide what the needs of the users are unless they are given instructions. If I can go back to integrity, I find it quite shocking that was 1.3, the members will be honest, open and truthful in promoting their business interests, has been removed. Why on earth would we do that? I mean, that is basically saying you can act like Del Boy in terms of marketing, but what you actually do must be okay. This cannot be a good signal to give to the wider world. It's just wrong. Finally, I'm very concerned about the extent to which more and more our non-professional lives are becoming ever more subject to all of this. To all of this stuff.
All right.
I can think of one particular case which I will put in my written submission. I don't want to name it publicly, but I don't think the amplifications or this covers a clear case of here is something, go and do what you want with it, and we're not responsible for what you do.
Well, look, shall we start with the competence and care point first? Neil, can I turn to you on that one?
Yes, I think that's one where we did discuss that at some length, actually. I mean, at the heart of professional relationships to make sure we deliver service that is appropriate needs, that helps serve as a public interest. And I think where we got to is, I think there's more in the guide actually to amplify this and help work through this. But sometimes there is a limit, and I think this also reflects the changing way the profession is working as well. There's much more discrete pieces of work that's being commissioned by a particular professional and some other discrete pieces of work elsewhere, which then contribute up to a whole. So it's sometimes difficult to see where the barriers are between the ultimate needs and a specific need in respect to that one project. And I think that's where the appropriate and so on and so forth came in. I think the guide is trying to help clarify that, and the fact that you might need other input from other professionals, which may include actuaries. You may have restricted pieces of instructions, restricted pieces of work. And I think that's a balance we're trying to seek. Now, whether we got it right, we'll take away that and reflect. But I think we are trying to reflect the changing world, the changing way in which instructions are given sometimes, the very restricted nature of some of the instructions for a wider project, and the multiple number of people involved in that project. So I think we'll take that away and look at it. But we thought we got the right balance, maybe we haven't.
And similarly, just before I come to you, sir, similarly, in relation to the point you're making about what was 1.3, members will be honest, open and truthful in promoting their business in services. As Elena said in the presentation, the view the Working Party came to, and I'm simply sharing this with you, the view the Working Party came to was, as Elena said, that was inherent in what we're saying about integrity, that we didn't need to voice it further. Now, maybe that's sending out the wrong messages, maybe it's presenting the position adversely, and we'll clearly need to reflect on that. Sir.
So my contribution is based on saying, well...
Your name first?
Beg your pardon?
I didn't catch your name.
Yes, sorry, Roger Grenville-Jones.
Sorry, Roger, for interrupting you.
I look at this from the point of view, what could I do which would put me in breach? I have three major areas of concern. Speaking up to others does seem to me to invite the comment, mind your own business, in a great many cases. I spend a lot of my time telling people that I don't agree with them. That actually brings me on to the respect for others. What does respect for others mean? I mean, it's so vague, it's impossible, I think, to say what it means. Does it say some people would say, telling somebody, I think you're wrong or you've done the wrong thing, is a lack of respect. In some cultures, it would be a lack of respect. And that puts us into conflict because we're meant to say what's going on. I think I'm leaving to the end my major concern, which is in my business particularly, but I think it happens more generally. Actuarial work is not actuary to client, it is actuary to employer. And what does responsibility mean in terms of communicating properly? Is it communicating with your employer or communicating with the outside world? It's very easy to have, to the clients, it's very easy to have a principle which says you must think what the ultimate client is going to think, but if your employer puts a barrier in the way and says, look, I, the employer, will decide what communication goes to the user, that puts the actuary in a position where, what does he say? He says, well, I'm not going to advise you in that case, so I'm resigning. But I've come across frequently, I came across a case recently which I wrote to the Institute about where a financial institution told me something which I knew was wrong. And they quoted, this advice came from our actuarial department. So I asked which actuary it was and they wouldn't tell me. And I asked the Institute, how do I find out which actuary it is? And the response I received, the formal response that I received from the IFOA is you're not entitled to know. So it makes a nonsense, I think, of large areas of work when the relationship between an employed actuary and his employer is so unclear.
Okay, and I think there's another question which is probably following this same theme. Yes? And then we'll go to the panel.
Fiona Morrison, the scope covering other conduct, there are some examples in the guide where sort of other conduct would be included, but actually it would be quite helpful to understand what other conduct, examples of other conduct that weren't felt to sort of fall within it, because that will help people understand the line and thereby perhaps help suggest some alternative drafting. And if I could just have two other very quick ones on things that have come up already this evening. I think Eleanor said that users is being used to replace the word firms to make it more internationally accessible. My colleagues are finding users quite confusing about what's meant there. And also, I think Eleanor said amplifications are examples. Well, if they're examples, let's call them examples, because it's a simpler term than amplifications, which has also been causing confusion. Thank you.
Okay, I'm going to suggest we pause there and bring in the panel, because I'm very conscious, and I'll come to you in a second, sir, I'm conscious that we hadn't dealt with the point you made earlier around the question of, well, I think your assertion was there was an expansion of the scope in relation to other conduct. And then we'll come to this wider question that we've had about comments in relation to speaking up. So dealing with scope, Neil, do you want to address that? And then I'll go to Wendy in terms of
yes, and scope in the context of the other conduct,
yes,
I think specifically.
Because I think that was the concern that was expressed there, which we hadn't dealt with so far.
We did think about this. We had quite considerable discussion, and I think we also explored alternative wording around the conduct that might reflect negatively on the profession. I think in the end we concluded that if you're a professional, there are certain expectations of you in how you conduct yourself in all sorts of parts of your life, not just in your actuarial role or professional life. Those two terms we debated at length as well. I think we arrived at the wording we did after a lot of thought and, I won't say compromise, but we certainly struggled to find exactly the right form of words to capture every occasion. But I think the principle we worked to was actually, if you're a professional, you're a professional. There are certain expectations. And if you're going to do something that's going to reflect on a profession badly or goodly, if that's the right phrase, then actually we ought to be thinking about how we apply the code. There are certain aspects of the code clearly that relate more specifically to traditional actuarial roles or actuarial work or actuarial input by non-fellows. But I think there are also other parts of our lives where we are expected to have standards of behaviour. And I think to the extent those are in the code, I think we want to include those. We also recognise that more and more as we expand the work we do as actuaries, but not perhaps in a true traditional actuarial role. I mean, that might be non-executive directorships, it might be school governor roles, it might be volunteer roles. The fact that you might have been put in those positions because of the fact, or with other people knowing that you're a professional and a member of the Institute, might bring it with it certain expectations. And I think we tried to capture that through the very succinct scope wording in the code, but we very definitely put much more in a guide to try and amplify, sorry, that's not the right word, use amplifications, examples, I think in this case, about how and where those things might be. I mean, I have to say, I don't think it's a black and white one. And you know, maybe John's comments earlier about, you know, if you're a professional, you probably will know when it's black, when it's white, and when you should treat the grey as dark grey and light grey. But we did struggle with that. And if you think there's a better way of expressing that, I think we'd be very welcome to receive those thoughts.
But I could add, and you may disagree, correct me on this, but I don't think the Working Party was purporting to propose an expansion of this other conduct scope. We were taking the view that it was an already implicit part of the code that we started with, and that we have not sought consciously, we may have done it inadvertently, we've not sought to consciously expand that. I think we'd point, using a UK example, that it would be settled practice, I think, that in professional regulation, this concept of other conduct would apply across the board in terms of professionals. Before I come back to questions from the floor, let me ask Wendy just to comment on the points that have been made around scope. Particularly, we might want to go to the sort of key point that Roger identified, if I can ask Wendy.
On the scope?
Yeah, sorry, forgive me, on speaking up.
Yep.
I do apologise, I misspoke there.
So the speaking up, we all agreed that it was a very difficult area, and it is one that you can be quite uncomfortable having to go along and challenge people on, and that was one of the main reasons why we looked at splitting it out as one of the separate principles. So the idea there is, yes, it was already in the code and you already had the support from it, but just by highlighting it as a standalone principle, then it just brings home the importance of how we do have that expectation that where you do see something, it will go along and be challenged, and it should be. Again, we didn't think that that was actually adding anything to the code. It was requirements that were already in there. We did talk about the speaking up at quite an extent, particularly just tying back to some of the questions as well, in relation to conduct outside of your actuarial role, because I think that's an area where it can get quite complex. So we were using quite a lot of examples and considerations to try and make sure that the wording wasn't extending the scope to sort of absurd levels.
Hence the materiality.
Yeah. And that was the reason why we went along and incorporated the materiality in some of these, how you have to go along and raise it.
But what of Roger's charge then, that if your employer says this is what you will say, or I'm not allowing you to disclose that piece of information, how would we expect a member to address the code as we currently propose it?
Mm-hmm.
It's very difficult, isn't
it?
Yes. I think it is very difficult. I think by having a principle-based code, hopefully gives a framework that you can use to help you. But I think one of the ones we did try and write, the traditional actuarial consultancy and client-type relationship, I think we're aware is still there, but there's many more other roles. Internal roles have always been internal insurance roles. We want to try and get a code we wanted to get a code that didn't rely upon the external client consultancy type relationship, that sort of traditional role. We hope we've made it more generic, and I think by using the principles, hopefully you can find a route through. So the conflicts, the free from bias, the communications for which you're responsible, should hopefully give you some backing for challenging that behaviour where you think it needs changing. Whether we've got it precise, I think we'd like that feedback from you. But I think there probably is. There are features in the code there where we can point to that help that situation. I think, as well, going back to the needs and instructions and so on, and working with internal roles, we have got a bit more in the guide as well about those, reflecting the fact there are more of those about these days than there were before. And hopefully that helps guide those internal actuaries on how they relate to their employer. And I think there's certainly a specific reference about agreeing scope instructions, for example, with their internal employers, their internal users, internal clients, as well as external clients.
Can I just add to that? It seems to be, going back to Roger's example, that it's one thing for, let's say, the employer, the firm, to say, this is what the firm is going to say in the firm's name. A rather different proposition for the employer to say to the employee, this is what you will say under your name with IFA after it. I think then there really would be significant problems and issues about an employer reasonably requiring. I can't see any basis on which an employer can reasonably require that. Remember, there are practice support services available through the Institute to try and help on that. But clearly there are issues we need to reflect on in terms of what we're proposing, what we're asking of people in this proposition, and the guidance we're offering. Now, I interrupted somebody over here to my right, and then we'll take things in the middle. So if we go to the extreme right there.
Yeah, thanks, Des. Brian Nimmo, just want to pick up probably a few questions I have around the use of the language in the revised code. One of them is probably following up from Fiona's point. There's introduction of a couple of new terms that have been liberally used in other guidance, users being one, misconduct being another. I think it would be helpful if we knew if they were supposed to be the same definition as in the TASs for users and in the disciplinary scheme for misconduct. And if they're not, maybe we should be using different terms. So probably just a bit of clarification around those words. I think that would be quite helpful. There's also the use of the word outcomes, I think in 5.3, 5.4, somewhere around there. It kind of strikes me that that's half a sentence. Materially affect outcomes of what? I wasn't entirely sure where that sentence was supposed to be going, so I just kind of parked that with the panel to give some thought to. There were two other things that are getting me kind of a little bit worried. The use of the word bias, which is not a new word, it's already in the code and I accept that, but I think our understanding of bias as a kind of community, I don't just mean actuarial, I just mean within the UK as a whole, the understanding of the word bias has moved on somewhat in the last 8 or 9 years to really begin to understand there's conscious bias, there's unconscious bias, and whilst not a strict dictionary definition, bias can easily be read as my preference. Not to bring my preference into actuarial judgment, I think, is quite tough. Now, whether that goes far enough to compromise that actuarial judgment, I don't know. There's just too many subjective words in that phrase. But I'm getting quite uncomfortable with the use of the word bias, because I don't think we truly understand what bias is. And again, just ask you to go away and ponder that one. And sorry, allow me one last point, and it's been touched on a little bit about our kind of outside actuarial roles. And again, it doesn't seem to tie up fully internally with all the rest of the guidance. So the scope, I think it's in the scope, or the application is talking about if the conduct could reasonably be seen to ... hit the profession's reputation. But within the disciplinary system, certain offences, such as a criminal offence, are deemed to damage the profession's reputation, and it's a prima facie case of misconduct. Now, I've not seen any evidence that makes a link between a criminal case and the actuarial profession, but we have deemed that holds. So the if bit in the beginning of the code doesn't really seem to stack up there, because later on within our guidance we take it as a given. So those are just a few kind of thoughts around some of the wording.
Okay, I think a colleague to your left there wants to follow on.
Thanks. Joseph Lowe. I like what you've said about bias. Fantastic. I've been co-authoring a Getting Better Judgment Working Party event, absolutely. And also about 1.3 as well. I would like to echo that. But my point is about 4.2, really.
About
4.2.
Yeah.
It's actually about the wording of it in terms of actually putting paragraph numbers of the disciplinary scheme of it. I mean, I see this document, it's a fantastic document because it's so nice and so short and everything, that I would like to be able to show it to, say, let's say, young people who would like to join the profession. But when they see, 1.11 to 1.14, I'm not sure whether I want to, it's not really that attractive anymore. In the same way, if I show this to my potential clients or to my potential employers, etc., who are thinking about hiring actuaries and all, when they see 1.11 to 1.14, they say, all right, these people are going to be a bit rigid, let's say, a little bit, a bit difficult, let's say. So yeah, I would like to urge the panel to think about that particular point, really.
Okay. Anyone want to comment on that? I think it's more a question of we've heard all of those points, so let me try and capture some more views. John, if you mind, I'm going to go behind you, because unless it's a new point you make. Go on, very quickly then, and then we'll go to the chap behind you.
Just on the principles, I mean, I take your point about they're generic. To me, they're so generic, they could apply to any profession. And I just wondered if we actually should be thinking a little bit about what is special about actuaries. Maybe there is nothing special about us. And we should reflect that within the principles within the Actuaries Code. If we didn't have Actuaries Code on the front page, this could be the Chartered Surveyors Code, the Solicitors Code, and I just wondered if the principles somehow ought to reflect what Actuaries do. And it's probably somewhere in the competency one. I suspect what makes Actuaries different is something about their set of competencies. And I just wonder if that should be in there. And on a second point, on the principles themselves, I think it's a mistake to take out improper conduct, especially in today's environment. We've seen today, the discussion about MPs and their behaviours. Now, I know it's sort of in amplification one of integrity about treating people with respect and all that sort of thing. But, I think, are we as a group, if we take out things like improper could be seen as looking after ourselves. And so we should be speaking up about improper conduct that we see among our colleagues.
So your assertion here is that improper adds something to unethical or unlawful?
I think it certainly does. I mean, unlawful is clearly unlawful. I mean, and certainly some improper conduct may be unlawful. Clearly, rape is an unlawful act. And one might argue sexual harassment could be an unlawful act. But, you know...
Or unethical.
Yeah, but the unethical we're talking about here is in the context of actuarial work. And I think, you know, I think we're talking about behaviours. Okay. But I mean, it could be there, but I'm concerned that it's, you know, it's not quite as explicit as it might be in today's environment.
Okay, take your point. Now, there was a colleague behind you. Let's go to him first, and then we'll pause with his comments from the panel.
Good evening. It's Tim Middleton from the Pensions Management Institute. I'd just like to ask about the impartiality principle in the context of the forthcoming CMA review. There has been a suggestion that some investment consultants have been rather too keen to promote the products and services of their own firms. And I'm just wondering about, regardless of anything that the CMA might conclude, is it not already the case that actuaries can find themselves compromised when they're in that particular situation, giving advice to clients, to the point whereby perhaps, you know, they're not so compromised that it's inappropriate for them to advise clients at all?
Well, let's deal with the wording of our proposed code first. Who wants to go on that one? Neil?
I think I'm steer away from CMA reviews and all that, because I think it's actually the code we're here to talk about, definitely. I think we've retained, in substance, pretty well what we had before. There's a conflict of interest there, there's reference to that, and there's there's impartiality and a bias. I think I'm not sure, in terms of what's changed from before, I think substantially there's little of substance that's moved on. I think we've got the perception now, which is there as well. I mean, my view is that we've got quite a lot there that's been retained in terms of, you know, conflicts and impartiality. Is your question, I suppose, should we go further than that? Is that really the substance of your question?
Is an actuary compromised if the business model of their firm is that there's an expectation?
Is an actuary compromised if the business model of their firm is such that there is an expectation that they should recommend a product or service by colleagues elsewhere in that same firm?
I think I should probably steer clear of answering that question directly, but I think we should take that sort of example away and see how it marries up with the code.
Well, it seems to me that potential example you're offering there of conflict must apply whether you're an actuary or an investment analyst or whatever. If you're being required or pushed towards a situation where you suppress your own professional judgment to pump the products of your employer, that obviously raises questions about compromise. But I think what the working party was focused on in terms of this particular principle, I mean, you know, what we're saying is that we see this as critically important. It's one of the 6 proposed principles, and that need for acting in a way that your professional judgment is not compromised and is seen not to be compromised, if I can use your word for a second, is central to what it is to be an actuary. And in that sense, I suppose our assertion would be, for purposes of debate, that sort of ethical base, that ethical foundation, would actually equip actuaries better than some other potential competitors post-CMA's pronouncements to actively continue to operate in this market. So, right, to your... Yeah, sir. Yeah, that's you.
Excuse me, Seamus Creighton. I'm associated with the NEDMIG, but tonight I'm speaking only for myself. And I'm reacting to the code as someone who is a non-executive director who happens to be an actuary, and I use that language deliberately. I welcome the architecture of the code in that I believe actuaries acting as directors have a responsibility for the reputation of the profession, and I believe the principles set out in the code do correspond with what would be recognised as sound principles of corporate governance. The amplifications too, generally, I think I welcome, with a couple of exceptions. Mm-hmm. The exceptions are in the areas of competence and care, and in speaking up where I think the amplifications are slightly tangential to what I think of as corporate governance as a team sport, where there will be debate about what's ethical, what are the interests of different stakeholders, and often one is required to compromise. So I think for non-executive directors, the amplifications under those headings may need a fresh look, but the others are probably fine.
Sorry, after you.
The final issue then is the guide, and I found reading this difficult to relate it to the context in which I work. There is a separate working party involving members of the profession and support from the regulation board working on guidance for non-executive directors, which will heavily emphasise the Actuaries Code, and it may be that guidance on the application of the code in the non-executive director context should be dealt with in there.
Can I just clarify, do I interpret your first point to be saying that your concern is that the way the amplifications within the code around competence speaking up, the way they might bear upon those of the IFO members who act as NEDs, is that we're almost, as it were, overexposing them to a litigation risk, as opposed to a collective risk that the board of ACME PLC is carrying, that they become more exposed, their obligations might be considered to be enhanced because of the code. Is that your point?
I wouldn't necessarily go that far. It was more that they seemed rather tangential to a process in which directors pool their various skills and experiences to arrive at an optimal collective decision. There are lots of wrong answers, but a few right ones.
Yeah, so it's the collective decision that, yeah. Thank you. Now, who'd like to come next? If there's a speaker right at the back, and then we'll come to, sorry, a questioner right at the back, and then we'll come to the front. To your right, that's it. And I'll come to you next, sir.
Thank you. My name's Tony Jeffrey. I work for the PRA, but I'm speaking purely personally. I've always been bothered about this lawful business, not for any UK laws, but laws in other places, and we are supposed to be applying across the whole of the world. There are plenty of laws which I find very, very unpleasant and unacceptable. And in particular, the number 5 on speaking out seems to require us to speak out if we're aware of any member acting unlawfully. In fact, sorry, I'll wind up back that thing on UK. If I became aware that 2 actuarial friends of mine were planning to go and get married in Belfast, and they were both male or both female, I would be committing an offence, apparently, by not declaring this. I think we need to try and just tamper that around a little bit somehow or other. I'm not sure how to do it, but I'm sure you don't mean this. I'm sure you don't mean that, you know, we should homosexual in Uganda or somebody speaking out the president in North Korea or so on, whatever. I'm sure that's not what you mean. Can we kind of fix that somehow?
Okay, does anybody want to comment from that? He said looking at his colleagues on his right-hand side.
Not really.
Not really, thanks.
Well, sorry, Willie.
I was just going to say, I mean, I think that's an helpful example to bear in mind, and that is certainly not the intention to go above and beyond, but we do need to bear in mind the lawfulness and the legal requirements of where you're acting.
And can I just emphasise that point? So let me start by taking your second example. So the code might get to a situation where we imperil one of our members operating in North Korea because he or she, in making writing a report on North Korean Insurance Inc., say something that might be construed to be an unlawful criticism of the president. What we're aiming to do is, through the code, avoid doing that. So if we're trying to avoid creating any such risk. And remember, in the draft that we put forward, and I'm looking here at paragraph 5 under speaking up, members should speak up if they believe or have reasonable cause to believe that a course of action is unethical or is unlawful. So let's come to your example about Belfast. So we've got, as it were, 2 people purporting to enter into, and I say purporting in the context of Northern Irish law, a same-sex marriage. Whether that amounts to we're creating an obligation upon members in that area, in that jurisdiction, having to, or thinking that they should speak up in those circumstances. Perhaps then there's an issue we need to think about in terms of looking away at the language. I think it's unlikely that the IFOA would be minded to take action against an individual in Belfast who didn't speak up in those circumstances.
Yeah, and I suppose the thing to just add there is that that was kind of where we landed on having a should requirement around speaking up. So the code generally for principals has must. For this we put should just to kind of take into account that there may be circumstances where it wouldn't be the right thing to do the speaking up. So that's why it's a presumption rather than this absolute mandatory must requirement.
So that presumption point being that so we're not expecting, the way we use should in the terms of our APSs is that we're saying there's a general presumption you should do something, but we recognise there may be circumstances where such a presumption would not be appropriate, that it is explainable not to follow the presumption. So we're trying to cover that point, but nevertheless, we need to think about the points you've made. So, who wants to come next? I think it was over here. Yes.
Pete Sayers. I've got an observation in connection with the speaking up principle. Firstly, I would say that I agree that we should have a separate principle on that. But I'm a little bit uncomfortable with 5.4, which is under the speaking up area, which concerns members taking reasonable steps to ensure users are aware of any substantial issues, ... if those issues may reasonably influence the decision making or judgment on users. Now, I'm happy with those wordings. I think the wording is in the wrong place, because if we actually look at the principle itself, the principle is to do with you have reasonable cause to believe that a course of action is unethical or unlawful. Clearly, this 5.4 is not looking at something which is unethical or unlawful. I believe, therefore, it should come under the communication section rather than the speaking up section.
Okay, so your point. Colleague want to comment on that? Because I know it's something we debated. Go on then, Wendy.
I was just trying to remember where it was, because I think this was one where we did debate where in the code it should go at quite a lot of length. So I was just trying to remember our conversations.
So I think the very charged assertion you're making was something that we were alive to. And something we
I think it needs to be in there somewhere, but it's nothing to do with the actual principle itself, so it's not an example of the principle.
Yeah, I understand. Okay, thank you. Who wants to come next? Just in the aisle here. Halfway down. Put your hand up, sir, so the microphone. There we go, got it.
It's David Martin again. We've had one or two examples to illustrate the point that I had made earlier about perhaps becoming too principles-based. And there are three that I have always felt I was required to follow in doing any piece of work, which are no longer explicitly there, and I'm rather worried that the more general wording that is there don't actually cover them for, just for example, a new actuary starting out looking at the code to help him or her. One of them is to be clear that you sort your remuneration out for the job before you start. That was the old 2.6. Another one was considering consulting the previous incumbent when you're taking over a piece of work. And the third one, and perhaps most important, is to, at the beginning of your report, to identify the client that you're working for. Now, I know there's talk about users, but it's all very general, and I think it's really important to identify who it is you are reporting to, as opposed to some other actuary who might be advising another party involved. Those are just three examples which I think should be done.
Very helpful. I'm conscious that the clock is against us, and I want to get as many comments from the floor as possible. So over here on my extreme right, by the wall.
Bryn Davis. Just in passing, I find 5.4 incomprehensible. I don't know if it's just me, but it's very difficult to understand. It's a very convoluted sentence. My major point is in relation to 2.4, because here, I think, unlike the rest of it, there's a parallel structure of the peer review requirements. I'm not sure this says the same as what the peer review requirements say. And the two obviously need to interrelate, and I don't know to what extent that's been taken into account.
Anybody want to comment on that?
I think it's one to take away, does.
In what way are you concerned that APSX2, the peer review problem, is triggered by 2.4?
Well, I read it as saying the same thing, that you've got to get other input if you're giving advice, so that's what the peer review requirements are. But the peer review requirements are much stricter than this. I think Simon's shaking his head, so maybe I've just sort of totally misunderstood it. But
okay. Well, I mean, I think the answer to your point...
This is referring to peer review.
Okay. I think your answer point is that we didn't look at 2.4 in the context that there was a conflict there, because our interpretation, subject to going away and thinking about your point, is that we didn't see them related. So we're saying that the obligations introduced by APXX2 in relation to a work or peer review relate to the need for a second pair of eyes or some form of a review of the work that you as a member of IVOA has done. Whereas we're looking at 2.4 is saying we think there should be an obligation that you must consider the need for other professional input in a particular set of circumstances. So I think, subject to hearing your point for this first time, we had not seen a link between them, but we'll go away and consider that. Yeah, I can see where you're coming from now, yes. Anyone else want to raise any other point? Right at the back.
Hello, Thomas Pickup. Just a fairly pedantic point about language, I suppose. There's an awful lot of use of the words should and must in this document, and it doesn't always seem to make a lot of sense or be consistent on this. So a good example is the speaking up as a should requirement. But if you actually read the detailed points, most of those are must statements. So you should speak up, but you must speak up in these other statements. But also as a broader point about must, is you're putting these examples, these illuminations, in must language. Surely they should be part of the core principle then. The point about a must language is there's no defense if you do something different. And if you're doing this as an example, that doesn't seem to make sense. I'm absolutely fine with the principles themselves using must.
Yeah.
But surely any example that comes under it is a should, because there could be unforeseen examples where this is reasonable. And using must broadly is dangerous if this is what we are going to be judged by.
Okay, thank you for that. And I think, again, across the middle of the aisle.
Thank you. James Wintle. Just to go through a couple of points very, very quickly in the interest of time. 1.3, that was in the previous code, actually I'm comfortable with us losing that. I don't think it added anything, and I don't think it was particularly well written as it was. 2.3 in the new code, as an example of what the previous speaker just said, I think that's a situation where the repeated use of the word musts in 2.3 could, in some conceivable circumstances, create a conflict, either within 2.3 or within other requirements, and maybe the wording there would be better as shoulds, or the previous code used words like take care to, which I think might be better there. Paragraph 4.2 is, as one of the speakers has already said, in a principles-based code, the detailed references to 111 and 114, etc., of the disciplinary code don't feel right. I am very comfortable making a reference to the disciplinary scheme in the same way that we make reference to CPD in 2.2, but the detailed requirements seem to go too far. My final point is one that hasn't really received a lot of attention this evening, which is the whole of Section 5 on speaking up, which is, I think, disproportionate in its overall length compared with the brevity and succinctness of the rest of this document. And I appreciate that it's the newest bit that potentially has therefore caused the greatest thinking among the working party. But my overall reaction would be perhaps going back and looking at the wording with a very strict eye for Section 5 might be worthwhile.
So thank you for that. I think I saw a hand over here near the front. Yes, so right on the edge here. There you go.
Is Philip Jarrett. I wanted to say something about the consultation process. In my experience, consultations either result in a major increase in the volume of the document that finally appears after consultation, or those really good ideas are not captured and they're just ignored. I don't really want the latter to happen, because I think quite a lot of the comments this evening were helpful, and hopefully your other meeting and written input will give you a good feel for what the members of the profession think about this new Actuaries Code. I'm very supportive of a principles-based code, and I think you're a long way along the way. I don't think you're there yet, though. But what concerns me, and I really would like to exhort you not to fall into the trap of dealing with the good ideas by expanding the guide. We don't need a bigger guide, we need a much smaller guide.
Well,
and a more balanced one.
On that mischief, that risk you mentioned there, that either consultations result in less or more, we've got a bit of a problem, because I'm hearing from you quite loudly that there's too much guidance and not enough principles. So we've got a bit of a circle to square there, but I do understand the point you're making. Can I just reiterate a point that I think Elena made at the beginning? Our policy is that we will issue a written document to record all of the points put to us in the consultation process, and we'll also offer an explanation in that document about how we respond to the various points that have been put, because we're actively seeking to engage with members here, and we're looking very, very assiduously and very genuinely at consulting and learning from the points that are put to us. So I'm hopeful that we can take the best out of this, and as I say, we're very alive to the need for an accessible document. I'm going to wind up now because the clock is against us. I need to do three things. First of all, I'd like to thank all of you for giving your time and coming along tonight, and for the quality of the various points that you have made. You have given a lot of food for thought to the working party. Secondly, can I just remind you about my comments that if you need CPD and you've not got a badge, you need to deal with that. And secondly, if you do not want to be included in the recorded film version that's going to go up on the website, you need to speak to me or to one of the IFOA staff after this event. And I know colleagues will be around for a little while if there are further points that you'd like to put or other things that you want to raise. And finally, what I'd like to do is ask you to join me in thanking our speaker and members of the Working Party for their contributions tonight. Thank you to them.